Hello, thanks for tuning in today. My name is Danielle Ward. I'm an attorney with the Blake Law Firm. Today we'll be discussing limitation of liability clauses in contracts. Today we'll cover what is a limitation, or sometimes referred to as an LOL clause, some key considerations for reviewing them, including who's covered, what is covered, and when to negotiate, and some other considerations. So what is a limitation of liability clause? It's a contractual clause that limits the amount or type of damages that may be recovered in the event of a claim, lawsuit, or breach. So they try to set the maximum exposure for a party or both parties in the event something goes wrong. They're routinely upheld by California courts so long as they're not unconscionable. So careful consideration should be paid to them when reviewing or negotiating them. So some of the key considerations, although there are many, is who is covered, what is covered versus excluded, and when to negotiate. So under the consideration of who is covered, look at whether it's just the contracting parties whose limitations are included, or does it include third parties? Does it include the shareholders, the employees, subsidiaries, or parent companies? And look at whether that limitation is mutual. In some instances, it doesn't make sense for it to flow both ways. But in some contracts it does. So double check whether that is included or not, and whether the provisions, if they apply to both parties, if they are to the same extent. So what is covered versus what is excluded is another big consideration. Typically, limitation of liability provisions will have a cap, a monetary cap on the amount of damages that can be recovered in the event something goes wrong. Consider whether that cap is mutual. In some instances, again, doesn't make sense depending on the nature of the business or the contract. But also, in addition to monetary damages, consider whether there are certain categories of damages, special or consequential damages, that are excluded. Sometimes the nature of the breach, the direct damages that result may be small. However, the consequential damages may be quite significant. So if those are excluded, you may be left without some recourse. Another thing to consider is including some language that would allow the provision to apply to the fullest extent permitted by law. The law continues to change through statute and case law. So what may be permissible in terms of a limitation today may be different when you try to enforce or apply the provision. So including some preamble that would save the provision may be wise. When to negotiate. Probably to nobody's surprise, it might be easier to negotiate a limitation of liability provision at the time you're trying to strike a deal. At that time, the parties are interested in doing business, and it's probably the best opportunity to negotiate whatever protections you need. It's also important from a risk standpoint to know what your potential exposure is before engaging in any transaction. Some larger companies may not provide you any ability to negotiate a limitation of liability provision. It's simply impractical for them to negotiate with each individual or smaller entity. And frankly, they can do away with your business if you're not willing to meet their terms. Even some mid-sized companies may not consider any negotiation of the limitation of liability provision unless your contract seeks a certain value to them. And that's just a business cost analysis for them. So there's other considerations besides the who, what, when. One of the things to look at, in addition to the limitation of liability provision, is whether your insurance coverage has some conflicting language as far as what is required. Some limitation of liability or contract provisions may require waiver of subrogation. However, some insurance policies or insurance companies do not allow for that. And insurance coverage is another way to provide kind of a stopgap in the event that the limitation of liability doesn't look like it's going to cover all of your anticipated damages. So it's something to see how they interplay together. Another thing to look at is contracts. Limitation of liability provisions may provide their own statute of limitations or some deadline, which will be upheld if it's in writing and reasonable, and if it appears to be the product of a negotiation. So in that case, the deadline may supersede what's provided by statute. So that's something to be careful to look at when negotiating, and of course, when you're reviewing that contract, if anything goes awry. So here are some sample provisions that I've included, just so you can see. The first one prohibits any indirect, special, or consequential damages. And the other one is just if there's any provision that's found to be inaccurate. So limitation of liability provision is just something that is set there to help the parties establish and negotiate what might go wrong. So it's important to consider in your particular business or this particular contract, what are the potential issues or injuries that may arise, and whether that provision will adequately cover you, and whether you have some other measure in the event that it doesn't, that will cover your losses. Thanks for tuning in. This is, of course, just a primer on limitation of liability clauses. There's much more to cover. If you have any questions or want any further information, please feel free to reach out to me or any of the other attorneys at the Blake Law Firm. We're happy to help.